Hello and welcome. My name is Jeremy Glover, and it's my pleasure to introduce our latest Fenwick Elliott webinar. This month, we're looking at final accounts, focusing in particular on the JCT and NEC forms. Of course, managing any final account process is of critical importance, not only for achieving the best commercial outcome, but also for trying to avoid disputes. And today, my colleagues Claire King and Katherine Butler will be comparing, and maybe contrasting, the processes provided for in the NEC and JCT standard forms and explaining how to get the best resolution for your project. My fellow partner Claire King is recommended as a global leader in construction by Who's Who Legal and in the Legal 500, which noted that she's excellent on strategy. She's the author of our regular Insight newsletter, which provides practical information on topical issues affecting the building construction sectors, and she was an author of the NEC and CLC's joint guidance on the use of retentions for construction contracts. Katherine is a council member for the Society of Construction Law, and I realise today, like Claire, she's a graduate of the MSc in Construction Law and Dispute Resolution at King's College London, where it turns out they were both awarded the Bickerdike Allen Prize for Best Examination Performance by a first-year student, and also the Society of Construction Law Prize for Best Dissertation. Further, like Claire, Katherine has been recognised as being a key player in the Fenwick Elliott team in the recent Legal 500 rankings. So I'm pretty certain you're going to be in safe and knowledgeable hands today. So just a reminder that you're all on mute. Please do send in any questions, and you'll be able to find a link to the slides put in the chat. But for now, over to Claire. Thank you.
Thank you very much, Jeremy. So what do we mean by a final account? We'll cover that briefly right at the beginning. There's obviously different terminology used throughout both contracts. We're then going to look, or rather Katherine is going to look at how the JCT final account process works. We'll then turn to NEC to compare the two, and finally we'll look at some common top tips as to how to put yourself in the best position possible, not only to resolve your final account ideally without a dispute, but also to get the best out of it in terms of money. So what is a final account? What I mean by that, or what we mean by that in this webinar, is the final determination of what monies are due under the contract in question. Obviously, I'm ignoring any latent defects issues for that purposes. And it's important to contrast that with interim payments. And I thought this quote was quite useful at doing that. At an interim stage, it's by definition interim. It doesn't have to be a wholly exact science. That's because the purpose of an interim payment is not to get a final determination of what you're entitled to. It's about providing sort of fair, maybe rough and ready progress payments to be made as you do the job. Contrast that to a final account. It's obviously very important to get that right. You want to make sure you are getting what you are due under the contract, or if you're an employer, you don't want to be paying more than what you should be. Now, some contracts don't have a final account process, or not specifically. Indeed, the NEC until the NEC 4 did not have a specific final account process. But others, and as we'll cover in this webinar, the JCT and now the NEC have fairly complex rules on how to close out that account, and they need to be followed. And as we'll cover, there are penalties if you don't follow those rules. There are real risks that you'll be stuck with amounts that you do not want to be stuck with. So without further ado, I will turn to Katherine, who is going to cover the rules under the JCT form.
Thank you, Claire. So first of all, thanks everyone for joining us today. I'm going to be taking us on a whistle-stop tour of the final account process under the JCT standard forms. So from a domestic perspective, the JCT is the most common standard forms, and so we're probably all going to have some experience of working with these contracts. And when you get to the final account stage, it's definitely a recognition that the hard work has been done. So with this talk, our aim is to provide you with that practical know-how and making sure that you can get the best possible end result. So I'm going to be focusing on the 2024 editions of the most common JCT forms, which are the design and build contract and the standard building contract. There are some nuanced differences in the final account processes under each form. So we're going to be looking at the procedure and timings for the final statement under the design and build contract, and the final certificate under the standard building contract. We are then going to look at how the final account is evidenced and the ways in which you can best prepare for the final account. And then we will move on to the effect of the final statement or final certificate and what the deadlines are to be aware of. Starting with the design and build form, clause 224.1 states that following practical completion of the works, the contractor shall submit the final statement to the employer and supply such supporting documents as the employer may reasonably require. So that's a fairly nebulous requirement, but I would suggest a good rule of thumb for contractors is that you should supply as many supporting documents as possible in order to support the final account position. Clause 424.2 gives us the main definition of the final statement, noting that it's documents setting out the adjustments to the contract sum, what the contract sum post adjustments should equate to, and the amounts that have previously been paid to the contractor. So overall, the final statement is detailing the final amount that would be due to the contractor, or indeed, in certain circumstances, due from the contractor to the employer. Within that final statement, the contractor needs to set out the basis on which the ultimate balance has been calculated and to detail any and all adjustments to the contract sum. So it's a relatively detailed document. Now we're going to take a look at the time frames. So with the design and build, the onus is on the contractor to set out its position on the final account within 3 months after practical completion. Now, that's relatively soon, and it's actually possible that you won't know what the ultimate balance of the final account will be at that stage. For instance, under the default D&B terms, you've got a 6-month defect rectification period, and if defects are notified in that time and for whatever reason the contractor doesn't remedy them, then a deduction can be made from the contract sum. So basically at this point, the final statement is the opening position for what will then be an iterative process to come to the final account prior to the due date for final payment. So in circumstances where the contractor doesn't issue the final statement, the employer can give 2-month notice for them to comply. And if the contract still doesn't do the final statement, then the employer has the opportunity to put over their position on what they say the final statement should be. That will then be the document that's discussed, negotiated, up until the due date for final payment. So we move on to look at the position under the standard building contract. So this contract refers to the final certificate rather than the final statement. And unlike under the D&B, the contractor is not responsible for preparing the final certificate. Instead, it provides all the reasonable, it's responsible for providing all the documents necessary for the contract administrator or QS to make all the necessary adjustments to the contract sum. So once that's provided, after 6 months, the contract administrator will then issue a statement of the sums due, which will normally be to the contractor, but not always. This is a different approach than under the design and build contracts. Here, the contract administrator's role is much more active in terms of determining the final account. Under the D&B, the employer's role is to verify the contractor's view of what the account should be. Another difference under the standard building contract is that if for whatever reason the contract administrator fails to issue this statement, there's no automatic contractual right for the contractor to issue its own. So that's something to think about in terms of, it's unusual, but it can create a bit of an impasse if you're simply not provided with that document. In any event, the final account process under both forms is both building up to the due date for final payment. So under clause 424(5) of the design and build, this sets out the events that will determine the time frame for the due date for final payment. On the default position under the excuse me, design and build, the latest date is likely to be the end of the rectification period, noting that the date in the notice of completion of making good could be later, but if no defects were notified, then there's no actual requirement to issue such a notice. Under the standard building contract, the timings are slightly different. Under clause 426, the final certificate should be issued no later than 2 months after the latest happening of the same event, so 1 month longer. And the due date for final payment will coincide with that monthly period for the issue of the final certificate. Calculating the due date for final payment is incredibly important. This is because obviously it relates to impacts on when people will ultimately get paid, but also it's important for the purposes of issuing any pay less notices, and it also has an impact regarding the effect of the final statement or the final certificate, which I will come on to a little later. So here, now we know where we are on timings. We actually have to get that final account squared away. Here we're setting out the ways in which the contract sum can be adjusted. Just as a quick note, the contract sum can only be adjusted in line with the terms of the contract. So if there were any errors in the contract sum to begin with, these are deemed accepted. So here is the only ways in which the contract sum can be adjusted either up or down. Some of these are more commonly engaged than others. For instance, variations happen on pretty much every project, but provisions allowing for adjustments on the basis of price fluctuations, they're normally deleted, and we don't often come across those in practice. So we know how the contract sum can be adjusted. Now we have to evidence those adjustments, and the red boxes here are giving some examples of how that can be done. So time doesn't allow us to go into a lot of detail on these points. I mean, that could be a webinar all of its own. But the main point to take away for contractors is that it's vital to maintain contemporaneous records of these costs. So, for example, making sure that you've got your invoices from the scaffolding company if you need that scaffolding for longer due to employer delays, or you've got your signed and dated timesheets for designers if there's been a change instructed to the employer's requirements. What we're saying is that the importance of these records and making sure that you keep your paperwork in good order cannot be overstated. So, as I alluded to earlier, the effect of the final statement or final certificate. So we've got our statement. We've arrived at our due date for final payment. There is a very important but often overlooked aspect of certain JCT contracts that deals with the effect of the final statement or certificate. So unlike other standard forms such as the NEC or FIDIC, the JCT doesn't generally include time bar provisions. So for example, unless it's amended, the JCT doesn't require a contractor to give notice of a delay event within a specified time, or else lose its potential entitlement to an EOT or loss in expense. Noting this, the major JCT forms include a time bar when it comes to the effect of the final statement or final certificate. So, under clause 1.8.1 of the design and build, at the point of the due date for final payment, the final statement becomes conclusive evidence that works meet the specific employer's requirements in terms of quality of goods and materials, that all EOTs have been awarded, and that the value of any loss and expense have been ascertained. This provision is seeking to make the final statement both final and binding. This will be the case unless one party commences an adjudication, arbitration, or other proceedings within 28 days of the due date. It's basically that this is suspending the conclusive effect of the final statement. So if there are any aspects of the final statement that you dispute, these have to be referred to proceedings within that 28-day time period, or else you lose your chance to challenge it later. So that's a pretty extreme consequence, and 28 days is a tight time frame. So this provision is largely mirrored in the standard building contract at clause 1.9. However, one of the major differences is that the elements of the final certificate which will become conclusive under the standard building contract have been expanded to include all necessary adjustments to the contract sum. This means that, save for the caveats that I've noted there in the italics, this is going to be conclusive evidence of pretty much the entire account, and this can only be avoided if proceedings are formally issued to formally challenge the final certificate within 28 days of the due date for final payment. So this is why it's incredibly important that we understand all the timeframes that I've just taken you through in terms of clauses, section 4. So, in terms of how the conclusive evidence provisions have been applied in practice, there's some useful guidance to be found in the case law. In the case of Trustees of Mark Gilbard 2009 Settlement Trust and OD Developments, the judge held that clause 1.9 timeframes will be upheld, and confirmed that all elements of the final certificate that are not agreed must be referred to dispute resolution within that deadline. Any matters not included in that dispute will be deemed to be accepted, will become conclusive evidence, and then cannot be challenged at a later date. So that's a point to make sure that if you are disputing the final certificate, that your adjudication notice or claim form is drafted as broadly as possible to make sure that you're not missing any elements of the final account. Just note as an additional point, this decision also highlights the need to be careful about the dispute resolution route that you choose. Here, the judge held that you couldn't start an adjudication after a claim form had been issued with the court. So the dispute had to go through the full litigation process when evidently the claiming party would have preferred to adjudicate. So just keep an eye on that. Then in the 2022 Scottish case of McLaughlin and Sons and East Ayrshire Council, this was again a standard building contract, but this had been amended. So along with the timeframes for referring the matter to a dispute resolution, so if that dispute resolution was adjudication, if any party wasn't happy with the adjudicator's decision, that dispute had to be referred to litigation within 28 days of the decision. So in this case, the employer didn't like the adjudicator's decision, but he was held to be out of time to formally challenge it because he waited 72 days before putting in the claim form. So the lesson here is to be on the lookout for additional amendments, creating other time bars, as these will be strictly enforced. So now we know that time bars will bite under the JCT. We've got to make sure that we don't fall foul of them. To that end, what do we mean by commencing proceedings? In Bennett and FMK construction, the judge held that the requirement to commence proceedings had been satisfied when a valid notice of an intention to refer a dispute to adjudication had been issued within the 28 days. This was notwithstanding that no referral was issued within the 7 days thereafter. This decision was supported by the case of University of Brighton and Dove House Interiors. In her judgment, Mrs. Justice Carr, as she then was, considered the position as being akin to facing the expiry of a limitation period. In that circumstance, issuing a claim form or a notice of arbitration is sufficient to stop the clock. So Mrs. Justice Carr established that the same rationale should apply to this provision. So, would note, it's worth remembering that commencing the proceedings only suspends the conclusive, the final statement or final certificate becoming conclusive. Clause 1.83 and 1.93, respectively, of the D&B and the standard building contract state that any proceedings will be treated as concluded if during any period of 12 months after the issue of the final statement or certificate, neither party takes a further step in them. So it's not possible to put an indefinite hold on the final statement or certificate becoming conclusive simply by issuing a notice of intent to refer. You need to take further action to conclude that dispute within 12 months. So now there is a little exception to the commencing proceedings under the design and build contract. So clause 424.6 says that clause 1.8, as we've discussed regarding conclusivity, operates as normal unless either party gives notice that it disputes anything in the final statement prior to the due date for final payment. So unlike commencing proceedings, which under clause 1.8, it has to happen within 28 days after the due date for final payment, either party can give notice disputing the final statement between that statement being issued and the due date for final payment. So what this means in practice was considered in the case of CC Construction and Raphael Mincione, which is coming up. So in terms of the facts, the contractor issued a final statement on the 1st of December 2020. That then started the clock running for the due date for final payment. 18 days later, the employer sends the contractor a letter saying that it disputes the final statement, but doesn't take any further steps to issue proceedings or start an adjudication, etc. When this came to trial, the contractor argued that the final statement had become conclusive evidence of the sums due. And this was because the 18th of December letter on its own wasn't sufficient to avoid the clause 1.8 time bar. And indeed, they asserted that the employer also needed to commence timely proceedings. The judge disagreed, and it was held that the letter was sufficient on the basis that the requirements under clause 424.6 as against clause 1.8 were different rather than cumulative. So this meant that the employer could either give notice or commence proceedings. It didn't need to do both. Now, I would stress that that is under the design and build. So unless that clause has been amended or you're working under the standard building contract, a party cannot challenge a final statement certificate simply by issuing a letter saying that it disputes that statement or certificate. It has to issue proceedings such as start an adjudication within the specified timeframes. So now that everyone's aware of the parameters and the enforcement of those time bars, just wanted to put up a couple of slides. So the conclusive evidence provisions are in the standard forms for the design and build, the standard, the intermediate, the management, and the prime cost contracts within the JCT suites. And they are not, as a rule, included in these less commonly used JCT forms. That being said, and my parting message before handing over to Claire is to always be on the lookout for amendments that impose deadlines regarding the final account, because this is a potential trap that has serious consequences. So my advice to you all is to check this early on and to put some markers in your diary. And with that, I will pass over to Claire to talk about the final account process under the NEC.
Thanks very much, Katherine. And it's also worth noting that sometimes you see amendments that don't actually seem to work very well. So it's always important not only to check the amendments, but to make sure everybody knows what they actually mean as far in advance as possible. So the NEC and the final account, as we all know, the NEC is designed, or was designed on purpose to have a very different approach to the one that the JCT has, in that, well, it's designed to be sort of collaborative with early identification of problems and a proactive approach to addressing problems, as per the quote here. So the idea at its core is that you deal with these things as they happen, so that you don't have a massive final account dispute at the end of the road. So obvious examples are compensation events ought to be notified promptly, and you forecast the effects after the dividing date. And we've already done a webinar on the dividing date and forecasting. But the idea is you're managing that risk, and there is an element of guesswork, and contractors may win some, they may lose some, vice versa for the employer, but the parties can move on. So up until the NEC 3, the final account process in the NEC forms was described as being conspicuously absent. And that was because originally it was thought that it perhaps wasn't required. Claims were going to be resolved prospectively along the route, so you wouldn't need this sort of rump process at the end to resolve your issues. So the NEC 4, June 2017, added this procedure, and it's called the final assessment procedure in the NEC 4 rather than the final account. This is the sort of the guidance from the NEC when it was published. This clause brings about the assessment of the final amount due under the contract. The parties should, of course, have been building up to this point, and very little should need to be done to close the accounts. So again, the ethos of the NEC is you avoid this classic final account dispute or process at the end of the job because you've dealt with it beforehand. Now, as a disputes lawyer, and at this point I have to say I am a disputes lawyer, so I have a certain take on these things, the question is obviously, is this the reality? You know, and we've done webinars on the disputes that we see commonly in the NEC on the various options, including obviously option C. But, you know, have quotations actually been agreed as the works possessed, or they sort of been parked with disputes noted with the idea that you'll sort of come back to them later? Maybe time's been separated from the money, or vice versa. You know, you've got the time, but you'll deal with the loss and expense issues in the way you shouldn't do under the NEC later. Has the amount of disallowed costs been agreed on a rolling basis, and there is provision for that in the NEC 4, or not? Has it been parked and you get a nasty deduction at the end? You know, have you complied with the applicable time bars, or is this in itself disputed under the NEC? Again, another one I see quite often is party using on-account payments because they can't quite bring themselves to commit to implementing a CE. And this contract doesn't really provide for that. So again, that's sort of a recipe for problems down the road. So this procedure is for those where maybe the NEC hasn't been followed in the way or the intent that it should be followed, and for some reason problems have snowballed. And if you are in that position, it's particularly important. So the deadlines. So clause 53.1, the project manager makes an assessment of the final amount due and certifies a final payment, if any is due, no later than, and there are two alternative deadlines here, 4 weeks after the supervisor issues a defect certificate. So that is at the end of the defects period. So say that is a year after you've completed the work, you should be knowing that this is coming up, and we'll come back to that later. Or 13 weeks after the project manager issues a termination certificate. Now, obviously, termination is a very different ballgame, although that could be for convenience as well, not just fault under the NEC. And you've got more time there. You've got 13 weeks to try and to get that issued if you're the project manager. And they're meant to give details of how the amount due has been assessed, so that you can consider that being a contractor. Then, if it's agreed, final payment is paid within 3 weeks of that assessment. So you should have lots of notice of when the works are completed, if it's in the normal course of things. So the defects period, the defect certificate, you should be knowing or have a very good idea about when that's come up. So you have no real excuse for not being prepared as a contractor, at least, for your final account position there. Obviously, as I said, long time period where the works are terminated, and that could be for convenience as well. So that's a different site situation, and I'll come to that later. If the project manager doesn't make that assessment within the time allowed, then the contractor has a chance to sort of nip in there and put their own assessment in. And again, payments then made within 3 weeks if there's no dispute. The guide very helpfully says that the project manager needs to be on the ball about this to avoid this happening. And obviously for project managers acting for the client, they absolutely need to be aware of this deadline, but equally as a contractor, you need to be keeping out an eye for it if they've missed it, because you've got an opportunity there to put your assessment in. But the sort of questions here that are sort of raised by the final account process in the NEC and how it's drafted, and it's typical NEC drafting. There isn't any case law on it yet, and it's relatively loose because it's meant to be this common sense language. So the obvious one is the project manager in a position to properly assess the final account based on the information provided, because actually there's no provision for you to put in your sort of submission as the contractor within this process. Now, the savvy contractor will have been putting in their applications before the defect date happens, but once once the defect date happens, the assessment period finishes. So you might want to be considering, actually, am I going to help the project manager here, or am I going to provide more information to the extent you haven't already anticipated that and been putting it in earlier, so that they're in a position in the run up to the defect date to really know what your account is about. And again, think about as the PM requesting additional information or backup in anticipation of having to carry out this assessment. There is no reason why you can't be requesting this information in anticipation. Obviously, it's different if you've terminated, if the contract's been terminated, but in the run up to the defect date, try and have that discussion or request the information as the project manager in advance to get on top of things, so you know what your assessment should be, and vice versa with the contractor. Think about proactively providing additional information to the extent you haven't done already throughout the job. So the message there is engage early. So do your homework, essentially. For the contractor, what is your position? Have you properly prepared your account where there are significant disagreements? By the defect date, you really should know what those are. And then you need to sort of step back almost. What records have you got to support your position? You know, devil's advocate, have I actually provided everything? If they are knocking off disallowed costs, is that because it's a matter of principle, or is it simply because you haven't really provided the records that you are meant to be providing under the contract? You need to go through the rules of what defined cost is, through the rules of disallowed costs, and really think about what you have got and what maybe you could provide to justify your costs. You need to be thinking about the timetable for next steps, dispute resolution into account in doing this, and I will cover those very shortly, but the point is you have a very small period once this process starts to actually get your act together. And unfortunately, certainly from a disputes lawyer perspective, what we see is a sort of last minute rush. Oh, we need to do this, rather than thinking, okay, the defect date is likely to be X date. I know there's a dispute or there's a difference of considerable amount on this. What can I do to get ready for this? And a key question that you may want to ask yourself is actually, do I need some expert evidence? Obviously, there's a cost associated with that, but if the dispute is a big one and the timetable is short, is that going to unlock the deadlock, or is it going to advise you actually you don't have such a good claim here? And is that the sort of work that you need to be done so you are ready, or at least you have an indicative view if you are going to have to take the next steps? So, for example, a delay claim where a CE for time has not been awarded or is disputed, or it's not accepted that it's as long as you would like. Do you need somebody independent to step in and look at it from a different perspective maybe and say, look, this is the position? So these are all the sorts of things to think about at this stage of the process, and ideally even earlier. Now, there is some debate, mainly in Keating on NEC, second edition, as to whether there should be an application of some sort of prompt payment, and that really isn't in the drafting, because the assessment date, as I said, finishes on the defect date where it's in the normal process, or termination certificate otherwise. So, you know, what does the PM have to work off? Obviously, they should have your previous applications and they should have enough information. But again, it's stepping back and thinking, am I doing everything I can do to help the project manager reach the decision I want him to reach the assessment and give me that money? And Keating suggests maybe amending the contract to provide for that extra sort of application or detailed package of information to support him making the assessment. That may be overly complex. It should be unnecessary if you've done your job as a contractor and you've put in your information when you've had a chance to do so. So it's suggested in Keating on NEC, but it's something to think about and should be unnecessary if actually you have done your homework in line with the megaphone on this slide. So deadlines. Now, this is a similar position to JCT in that unless you take certain steps, the assessment is speech marks conclusive evidence of the final amount due under or connection with the contract unless a party takes the following actions. This will be enforced. It's a condition precedent. It's a pretty clear condition precedent. English law on condition precedents is relatively harsh. Well, it will enforce them essentially. So you need to be aware of this timetable, and Katherine has done a timetable here to show the next steps in graphics, which we'll come on to looking at option W2 later. So 4 weeks, you need to dispute it, and it needs to be referred to the senior reps for discussions. Under option W2, which is the Domestic Housing Grants Act provisions, which is the ones we come across, certainly domestically, obviously the most. You've got 1 week to then put your statement of case in, 3 weeks for senior reps meetings, and then you have a list of issues that are not agreed, or and a list of issues that are agreed, and that is essentially your agenda for adjudication, at which point you've got 3 weeks to refer it for adjudication. So all in all, this is very tight, and it's amazingly how often this process falls over the Christmas period, making it even tighter. I don't know if that's just my luck. But the point is, you have to be aware that this is a tight timetable and you need to plan for it. So, option W2, if you disagree with the final assessment, you need to be referring it to the senior representatives or adjudication within 4 weeks. Unless, strategically, maybe you want to do an ambush, but it's amazing how effective, in my view, the senior representatives process can be. If it's used properly. The idea of senior representatives is that they're removed from the day-to-day project politics. So maybe if things have got too embedded, it's got too personality based. They can sort of stand above it and have a sort of more objective view of how things have gone on the final accounts. But obviously at the same time, they need to know enough about the project and about the account to actually have a view on it. So with that in mind, this is your senior reps checklist for the process. You need to check the notice provisions in the contract. So for example, do you need to issue on CMAR? Do you need to serve a letter? Is it email okay? Check those, do not get them wrong, and don't leave it to the last minute, because obviously that is an absolute deadline. Do you, as if you're the contractor, have senior representatives appointed? Do the other side, the employer, have senior representatives appointed? Have people moved on? Sometimes the names don't get updated. So you need to think about this in advance, make sure that sensible people and people who actually work for you are still listed as the senior representatives. You need to think about your statement of case. You need to be prepared to draft it. It's got a page limit, 10 pages. So what's your focus? What are the real nubs of your dispute? Again, if it's a matter of principle, that may be easier to deal with. If it's very detailed and money related, there are different ways to deal with it. So you need to give some thought about how you're going to deal with that. Are your senior reps available in that 3-week period? Again, if they're very senior people, this can be difficult. Are they in the country? Is it Christmas? Are they on holiday? All these sorts of issues come up with alarming regularity, so you need to anticipate them. You've got to brief your senior representatives. As I said, it depends who they are, but if they're senior and they're not in the day-to-day, you need to make sure that they know your position, they know your strengths, they also know your weaknesses, so they can negotiate properly and make sure they get a good deal at the end of the day. Is it worth agreeing in the year 2 for the whole process? 3 weeks is very short, or actually is that timetable quite helpful for keeping the pressure on, because everybody knows what the next step is, i.e. adjudication. You need to ensure the list of issues to be decided is comprehensive. Does it cover everything? But equally, you've got to think about how you structure your list of issues that are agreed and not agreed at the end of the process, because that is then your agenda for adjudication. So all of this process needs quite a lot of thought, ideally in advance, so you're going into it in the best possible way to get the best result. Then in terms of process, you have the list of issues that are agreed, issues not agreed. The next step is very clear, it's adjudication under option W2. And then you've got a 3-week deadline to launch that adjudication, or that list of issues becomes binding. So again, 3 weeks is not very long, especially if it's a large and complex dispute. Things to think about: do you want to be preparing for your adjudication? If you think settlement's unlikely, it's not the best attitude to go into the senior representative, but it can be a realistic one. Is it worth preparing in process? Are you really in parallel so that you're ready? Think about that. Engage experts if you haven't already done so. Again, good experts may not be available 3 weeks to prepare, could put you at disadvantage, so that's things to think about. And then, assuming that you don't get the result you want in adjudication, you also need to be aware of the next range of time bars in the NEC, which will be enforced, and there is case law on this, which is issuing a notice of dissatisfaction. You've got to issue that within 4 weeks, or the decision is binding. And again, you need to be really clear about what you're disagreeing with, because court or arbitration are the next steps, and you're going to be narrowed by what you disagree with. And again, there's case law, and we've written on this on our website on how specific you need to be on the notices and serve it properly. So all these sorts of things are very similar actually to the issues in the JCT. And with that in mind, top tips, sort of drawing it together. Katherine obviously covered in her section, and I've covered it too. Records, and more records. It's a standard mantra for any construction disputes lawyer, but you need to be able to justify your claims. And if you have good records and you provided them, and you've got your backup all organised, it's the chance of you going to dispute resolution, the next steps or adjudication, are significantly reduced, because people can see you're ready and they can see you've got a good case. As we've said, you've always got to check the contract. Anticipate the timings. Are there any bespoke amendments? It's amazing the number of times people think, oh, I'll just fiddle with this, and then you're looking at it in retrospect as an outsider and thinking, I don't think this works. What actually does this mean? And then you have to make sure that you take the most conservative approach, because you can't risk being wrong on that. Start early. The earlier you think about these things, get your records ready, get your experts engaged, get your senior reps prepped, etc., the better you're likely to do in the process, is the rule of thumb. One thing we often get asked is, should I speak to them? Or should I just sort of shut up shop and that's the end of it? Open lines of communication, my view anyway, is you always keep that line of communication open. It's amazing the number of times that works. Shutting the door is very rarely the right thing to do entirely. You need to make sure that you've got, even if it's a back door somewhere, you've got that communication going on throughout the process, because it can be extremely useful, sometimes when you least expect it. Plan out your contractual timeframes. So Katherine's obviously set out the JCT ones that you need to be really aware of. NEC equally, there are strict deadlines and they will be enforced by the courts. Plan those out, be ready for them. And then number 6, be ready to adjudicate. Now, obviously, nobody wants to adjudicate. We're all hoping we won't have to. But if you've got a conclusive evidence provision and the option is adjudicate or be £1 million short, or even more than that, you need to be ready, because 3 weeks to prepare something like that, for example, in the NEC, is not that long, and it will be putting you at a disadvantage if you haven't done your homework in advance. So with that in mind, hand to Jeremy.
That's brilliant. Thank you both very much indeed. That's very helpful, clear, both from sort of the contractual steps and so lots of practical advice as well. We've had some questions, and Claire, one is seeking, I suppose, 1 or 2 practical tips about specific NEC form. Option F, the one for cost reimbursement. I wonder if there's any sort of best practice tips you might have if you're using sort of the option F.
Yeah, so option F is the management contract, which I think the key thing is there it's subcontractor cost plus fee. So you need to be making sure that your subcontractor costs are properly evidenced. I mean, the rules on disallowed costs with subcontractor costs and defined costs are fairly similar to the option C ones, essentially, and option E. But the golden rule is, evidence that money should have been paid, obey the rules in your contract and provide the documents. And quite often with those sorts of contracts, people want to see the accounts evidence that payment has actually been made. So you may need to open up your coin system, for example, and have that sort of payment information available, which can cause problems with data protection, all sorts of things. So just anticipate that and maybe invite an early audit. You know, there's a rolling process for defined costs. When it's ready, you can invite people in to audit it, and then they've got 13 weeks for that process. So get that done during your contract, because then you won't have to do it at the end, essentially. And memories always fade slightly towards the end. So it's best to do it rather than later.
Okay. Perfect. This might be for both of you. Are you obliged to carry out variations instructed by a contract administrator or an architect after PC? It's not strictly final account, final statement related, but it's sort of, I suppose it's the defects notification or the or period, whether you're actually obliged to carry out these variations.
Well, a variation that post PC that alters the employer's requirements is a little sticky because you've achieved practical completion. So I'd be surprised. In terms of an obligation, I don't believe there is one, because you have complied, you've delivered what you contracted to. But you're more focused in the post PC period about remedying the notified defects as opposed to a variation. You are obliged to fix properly notified defects, but if you don't, the consequence is that your contract sum is reduced accordingly. If you don't undertake it, then you'll get the cost of what it costs the employer to get someone else to do it.
The thing I'd say is no, but then there's sometimes a grey line between what is a variation, what's a defect rectification, or sometimes people agree to do things and then it's sort of added into the post-PC world by some sort of side agreement or an express agreement. But if you are asked expressly to do something after PC, then I think you'd probably want to be sort of documenting it and the conditions for carrying that out work if you decide to do it, and obviously get payment for that work.
Yeah.
Okay, no, that's perfect. I've got a couple of questions about time periods. I think they're JCT based. Katherine, you were talking about the fact that a contractor has, under a D&B contract, 3 months to submit their final account, and then if they don't, the employer's then got 2 months to request them to do so. Is that shorthand for saying, well, the contractor's got 5 months to do it? I mean, good practice, but
in practice, yes. You probably won't make yourself any friends with the employer, because in order to sort of move that process forward towards the due date for final payment, the employer is going to be starting doing their own assessment. The benefit to a contractor is that it gets that sort of opening salvo under the D&B to say, this is what the final account should look like, and it's then for the employer to pick holes in it. The contractor's necessarily going to be on the back foot if they wait for the employer to prepare its own statement. So I'd say being proactive and not necessarily considering that you have this 5-month period to do that in would be the better option.
Yeah, no, I understood. Right, there's another one about the time periods an employer has to make payment. If the due date for final payment is 1 month after the end of the rectification period, if we assume the rectification period is a year, does that in effect give the employer a window of 13 months before they have to make payment?
Of the so the ultimate final account payment, yes, depending on what the sort of the defects rectification or when the certificate notice of completion of making good. But you must remember that there's after practical completion, the contractor's still able to issue interim applications for payment. It's not that PC is a dividing line in terms of no more money until the final account. It's interim application can still be issued, and the same rules for the employer to issue pay less notices and to abide by all those cash flow restrictions, they still apply. So it is the final payment that could be 13 months later, but it's not the only payment that can be made in that period.
Yeah, absolutely, and that's why you quite often see almost final or almost the last interim payment application is very similar to what the final one would be, which I suppose sometimes for some contractors or subcontractors is like 2 bites at a cherry with the sort of the final.
I'm sure it's not on purpose, Jeremy. I'm sure it's just a coincidence.
Yeah, no, I'm sure that's right. I'm sure that's right. Well, thank you both. We're just coming to a close. I should say we've had a question about highlighting briefly the final account procedures under the FIDIC Red Book, and that might actually be a topic for another webinar. But just incredibly briefly, a couple of things about FIDIC. The FIDIC form itself doesn't have payment notices and pay less notices unless, which is something to think about if you're operating a FIDIC contract in the UK, because you would then become subject to those notices under the Housing Grants Act. But apart from that, I mean, FIDIC has broadly, in very general terms, similar processes with a statement of completion after taking over, and then they have a final statement process. And one thing that FIDIC does, which I think is slightly different, with the final statement, they have something called a partially agreed final statement, where the parties are under obligation to agree everything they agree, and then which is the partially agreed final statement, and then they hopefully have a very small number of items which are the disagreed items, which can be more hopefully easily resolved through some kind of dispute resolution, dispute avoidance process, therefore avoiding arbitration. But as I say, that's probably a webinar in its own right. But Katherine, Claire, thank you very much again for both your presentation and also dealing with a number of the questions that have come in. It's much appreciated. So it's just time for us to advertise our next webinar on the 22nd of May, Navigating 2025. We're all aware of all the pressures on construction industry, which seem to be changing and probably increasing every week. So we thought it'd be time to provide 1 or 2 practical tips for overcoming the challenges that we all see on construction projects today. So hopefully we'll see you all again in about 4 weeks' time. Thank you very much.
Thank you very much.
Bye.